So we are live. Oh, I think Anne-Marie has dropped. Oh, we will wait for some participants to come into the room. You can see that our numbers are going up as we speak. And we're just waiting for Anne-Marie to come back on the call. So good afternoon, everyone. Thank you so much for coming along today. I am Emer McNabb. I am head of memberships at the ISE. And today we have a great panel of speakers to talk to you about the hiring international students, a very hot topic for us at the ISE at the moment, specifically looking at visas and sponsorships. We ran the session around a year ago. I'm going to look at Tal and Kieran to see if their heads start nodding at that. And since then, there has been more changes to the scenario. So I think Anne-Marie is on mute. If Anne-Marie comes off mute, she will come on the screen. I'll hand over to Anne-Marie now, who is our new head of insights.
Thank you. Sorry, can you hear me
Measure.
okay?
Yes, we can hear you perfectly.
Fantastic.
Thank you,
Apologies for
Anne-Marie.
that. Just as soon as we were about to start, my connection dropped, which is unfortunate. So many apologies for that. Yeah, thank you very much, Emma, for introducing the event. So just to recap, so I am Anne-Marie Campion. I am the Insights Manager at the ISE. And we are very pleased, very happy and very thankful for our supporters from Paragon Law on this webinar today. So Tal Vashista, Kieran Abbas and Andy Poole, covering this, what I think will be a very lively discussion, a huge amount of information on a subject that we have had a lot of contact from members. And the way in which the webinar will work is that Tal will lead and will run through as much content as we can cover. We've already had questions in advance from members, so thank you for sending those through. But please continue to ask your questions throughout the webinar. Use the Q&A section, if you will, on that tab at the bottom of your screen, rather than the chat. We will all be picking up questions throughout the webinar, and the Paragon Law team will answer those as we go through, as you post them. So we're getting some immediate answers to those questions. And there'll also be some time that we'll leave towards the end of the webinar where we will pick up further questions. So please feel free to ask as many as you have, and we will cover as many as we can within this session today. So there is a lot to cover. So Tal, I'm not going to say any more now, but hand over to you and please lead us through our discussions.
Thank you for that wonderful introduction. Look, in terms of Paragon Law, we're a niche immigration law firm. We've been doing immigration law since 2003, and I've been practicing in this area since 1996. So I've really seen the development of work permits through the old WP1 scheme, those of you who are on the call that will remember that, through to sponsor licensing that was introduced in 2008, and then all the different changes that have taken place to that regime leading up to Brexit, and the significant changes that happened then, and the changes that have occurred since Brexit as well. In terms of anything you want to know about Paragon Law, Kieran Abbas, myself, or Andy, just feel free to go onto our website, and there's a lot of content and information there that we share. The topics that I'm going to share now, for some reason, my screen isn't moving. Don't know why that is. Just seems to be stuck there. I don't know if okay, I'm not sure why.
Tal, are you sharing your slides or is somebody else sharing the slides?
No, I'm sharing them, but I can't seem to. Okay, I don't know what happened there. Forgive me for that. Session outline. This is the areas that we're going to be focusing on. So you've got working on a student visa. I just want to really touch on that very quickly. We'll then talk about graduate visas and apprentices. Kieran will then talk about the skilled worker visa and in particular changes to the standard occupation code, salaries. I'll discuss costs and clawbacks. There's been recent changes with regards to that. I also then want to touch on the government authorized exchange scheme, which may be of benefit to some of the attendees. We'll then focus a bit of time on job advertising and avoiding discrimination. And then a bit of navel gazing in terms of what's next in 2025 and 26, and hopefully leaving at least half an hour or so for Q&A at the end. We're not going to be able to touch on every subject in too much detail just because of the content there is. And, you know, ideally, I really did want to focus some of my time on compliance and maintaining your sponsor license, but we simply don't have time for that. But I may touch on that as we go through various slides, you know, really for you as recruiters to impress upon the teams that look after their sponsor, look after your sponsor license, to ensure that they're maintaining it, updating it, and making reports when required, because sponsor licensing auditing is picking up quite a lot, and revocations have picked up in the last sort of 12 months. So I'm going to start with a scenario here. Emmanuel is a Nigerian international student, aged 30. He completed his first degree whilst in Nigeria in business management with the Open University, and he will complete a master's in finance at Loughborough University next summer, which he started this academic year. He is currently doing voluntary work at a local charity shop and is trying to secure part-time work. He's also applying for graduate trainee, internship, and apprentice roles in accountancy. He has left his wife and baby son in Nigeria and is keen to have them here with him. So quite a bit there to unpack, which we'll do in the next sort of 2 or 3 slides. The first point to note out is a previous change that took place back in January 2024, which was the first change really for international students, which was to prevent those that were studying a degree level course or below from being able to sponsor dependents to come with them. So that changed, and that's something that Emmanuel needs to be aware of, particularly as his postgraduate course is not a research course, something which involves at least 50% of research time. It's just a straight business course, meaning that he still is unable to bring his dependents to the UK. Student dependents who are already here, there's no issues with them, and they are able to extend their status alongside the main applicant and also switch status as well. So if Emmanuel did have his family members here, they would be able to, for example, switch to the graduate visa or the skilled worker visa. Another important rule change that took place back in 2023 is that students on a degree course must firstly complete their course before they're able to switch to the skilled worker route. Prior to that, you were finding that students were just coming to the UK using the student visa as an opportunity to get into the UK and then started to look for employment. And I think the UKVI caught on to that. And so they want to ensure that students complete their course. But as employers, you're able to interview international students, and you're also able to assign a certificate of sponsorship, but the start date on the certificate of sponsorship must be one which is after the course completion. So it's important for you to liaise with the university that the student's attending to ensure that you have the correct course completion date, and therefore you can add the correct date on the COS as to when the individual's course is completing and the start date. There is an exception for PhD students who can, PhD students will be here for up to 3 years, and they must spend at least 24 months as a PhD student before they're able to switch into a skilled worker visa. Other considerations for HR should a business offer a manual employment whilst he's an international student, is that they need to ensure that he's contracted to work for no more than 20 hours a week. And obviously these hours can be increased during vacations. Do note that if he was on a sandwich course, which meant that part of his course required him to gain work experience in industry, so long as the work experience is no longer than 50% of the total duration of the course that he's studying, during the sandwich course, he would be able to work full-time without any restrictions. This is very important, and a lot of employers do get this wrong, that whilst a person is on a student visa and has been offered employment, you must be giving them they must be offered a fixed term contract up until the date of the expiry of the student visa. We've seen a couple of employers that have been audited recently, their sponsor licenses have been audited, and when reviewing personnel files, this issue has come up as one of the reasons to certainly in one case suspend a license. In its own, it wouldn't be an issue. It's something that can be rectified, but if it's one of a number of things that are picked out during a compliance audit, then it does work against the sponsor. Whilst on a student visa, there's no minimum salary requirement. Obviously, national minimum wage applies, and then also from an employment law point of view, they must be paid the same salary for the same work that a resident worker is doing as well. Right to work checks, hugely important. Obtain a letter or other document from the university confirming when the course is completing and when term time dates are. Carry out the Home Office online right to work check using the share code, and then mark up the expiry date of the visa for you to do repeat checks as well. If you were employing manual and say he was doing a 2-year course and you employed him in his first year, I would recommend that you do repeat checks at the beginning of the second academic year, just to confirm that he is still a student and still attending the course. So obtain another letter from the university. One point that I want to highlight here, I think I put this in my slides next year, but I'm emphasizing again, is the importance of A, doing right to work checks, and B, offering international students the correct hours based on term time and outside of term time. So Tesco's back in 2012, one of their depots in Croydon was visited when they found that 23 international students were being given 70 hours per week during term time, as opposed to 20 hours. At that time, when it was £5,000 per worker, the fine that Tesco received was 115,000. As of March 2024, when the fines are now £45,000 per worker, you'd see that Tesco today will be fined £1,035,000. So really, it's important to ensure that line managers and those that are responsible for the people that you hire are aware of the rules with regards to hours and generally right to work checks as well. Certainly in the last quarter, the UKVI has issued 700 civil penalties to businesses. This is the last quarter of 2025, which is a 50% increase from the previous year. And they have confirmed that as part of their activity on reducing net migration, that they are going to be looking to visit businesses and look to see whether businesses are carrying out the correct right to work checks and retaining documentation to confirm that they've done that as part of their statutory excuse. So the graduate visa, I'm sure all of you are aware of the requirements of the graduate visa, which is that a person must have completed a degree level course or above. They must have successfully completed that course, and that they are switching to the graduate visa in country, i.e. they're not making an application from outside of the country. They must be switching in country. Currently, and this is particularly up until January this year, next year, graduate visa holders are being given 2 years leave to remain in the UK, and those on PhDs are being given 3 years. The graduate visa allows you as employers to sponsor international students switching into the graduate visa without the requirement for sponsorship. And when it was introduced by Priti Patel, who was the Home Secretary at that time, she very much said that it was to encourage employers to try and test international hires, the brightest and the best international students, to train them, to develop them, and then to get graduates to a stage within the business where a business would then want to go through the expense and red tape of sponsorship. So that was the idea at the time, and really giving what as they coined the phrase, the brightest and the best international students the opportunity to work in the UK. The immigration rules that were laid in Parliament last week on the 14th of October has confirmed, as was stated in the white paper that the government would do, has confirmed that the graduate route will be reduced to 18 months for all applications from the 1st of January 2026, therefore meaning that it's unlikely to affect this year's summer graduates who will be given leave to remain till December, January, sometimes longer, but so long as universities are advising them to switch status before the 1st of January. So long as they file their application before the 1st of January, then their decision will be considered under the old rules. But if the application is submitted on the 1st of January onwards, then it will be the new rules, and they'll be granted 18 months leave to remain in the UK. Now, I really don't know what the strategy behind reducing it to 18 months is. They were thinking about other strategies with regards to the graduate route. Some of them included, for example, only allowing graduates from certain universities to switch to the graduate route, or only allowing graduate route holders to take on RQF level 6 type of roles, i.e. graduate level roles, which we'll touch on in later slides. So I guess if they were going to do anything with this, the fact that they've just reduced it to 18 months, regardless of which university the graduate's from, and the fact that the graduate's able to take on any type of employment to some extent in the current climate, is somewhat of a win as a concession if we had to give one, compared to other things that they were looking at. So from an employer point of view, one thing that I'm sure you're aware of is that if you were to directly employ an international graduate directly into the skilled worker route, so if you were to sponsor them directly, then you are exempt from paying the immigration skills charge, which, depending on the size of your business, is £1,000 per year for each year of sponsorship, or £364 if you're a small business or charity. And also for the 4 years, it allows you to rely on the new entrant salary threshold as well. So as part of your workforce planning, and particularly with regards to new talent, this might be one thing that you want to be looking at, is whether you want to bypass the graduate route and go straight onto the skilled worker route. Another advantage potentially to that is that the government is looking at increasing the time period to settlement from 5 years to 10 years. And there is still doubt as to whether they will implement that retrospectively for those that are already on a pathway to settlement. So someone who's already on a skilled worker visa. And therefore, as a cost-reducing exercise, it may be something, again, as part of your strategy, that you look to recruit graduates at this stage to the skilled worker visa. We had a few questions prior to the this presentation about apprenticeships and the funding rules and how that related to eligibility criteria for non-UK nationals. And your guidance here and what you really need to be looking at is the apprenticeship funding rules that were published in July this year and relates to apprenticeships between August 2025 to July 2026, and in particular referred to Annex A of the rules. And what it will say in respect of non-UK nationals is that they have to have been ordinarily resident in the UK for at least the previous 3 years before the first date of their apprenticeship. So if we're looking at an international student, so far so good. If they've been here having studied a degree for 3 years, let's say, for example, so they meet the 3-year period there. But then it goes on to say that whose ordinary residence in the UK, any part of the 3 years is not based on receiving full-time education. Okay, so that basically takes out any international students who you might be looking to offer an apprenticeship program directly out of university, because the previous 3 years of their leave of their ordinary residence has been here as an international student. And that have permission granted by the UK government to live and work in the UK, and that such permission is not for education purposes only. So if you look at someone who's, let's say, has been here on a graduate visa for 3 years, for 2 years, and then they're applying for an apprenticeship program. So let's say if we take into consideration 2 years on the graduate program and then 1 year as an international student, one can argue that the permission hasn't been granted here just for education purposes only. The last 3 years hasn't just been for education. 2 years of that has been them being ordinarily resident to look for work and taking on employment. But the Department of Education defines ordinarily resident as a person who habitually, normally, and lawfully resides from choice and for a settled purpose in that country. This is where it gets a bit grey as to whether someone on a graduate visa is here for a settled purpose or a temporary purpose. And my view, when you look at that in the round, is that it's going to be difficult for international students to be able to justify that they are able to go onto an apprenticeship type program. The other point to note, yeah, go on.
Sorry, Tyler, just jumping in very quickly, just on that apprenticeship piece, because I know I've heard this from members before. Specifically, typically most employers will recruit an apprentice who's not at university. They will be at school or college. They may be going into a degree apprenticeship, but by definition, they would be at school or college. And the example that I've had in my past life as a head of early careers in an employer were students who are with expat, so their parents are expats. They're by definition living and working abroad, and their child is resident in that country abroad at an international school. The parents have a family home still in the UK where there might be other relatives living in it, but that child is living currently abroad at an international school. Is there a quick answer to whether how that residency rule applies to that person?
I believe Annex A to the rules that does discuss that. And I believe there is an exception for someone who is a British citizen, but the purpose of them being outside of the UK in the previous 3 years was to gain education. So if they can prove that they were at a foreign university or at a foreign school in the preceding 3 years, then I believe that's an exception, and they will qualify for apprenticeship funding.
Thank you. Sorry to interrupt, Hal, but I just wanted to ask that
that's
whilst
fabulous question.
I felt it was relevant. Thank you.
Yeah, but Annex A is a very easy read. I would say, have a look at Annex A and also refer to Appendix A for special groups of migrants, such as refugees, those on humanitarian protection, Irish nationals, Ukraine visa scheme holders, because there is exceptions to them having to having to satisfy the ordinarily resident route requirement for the previous 3 years. So, skilled worker visa. One thing that's really been quite stark is the increase in salaries that's taken place really since April of last year. And you'll see here that pre-4th of April 2024, that the general threshold for salaries was 26,200. A new entrant, and at that time there was shortage occupation list as well. The floor salary was £20,960. Post 4th of April 2024, you'll see that the general salary threshold floor salary increased quite significantly to £38,700, and the new entrant and then the shortage occupation list was changed to the immigration salary list, increased to 30,960. And possibly one of the most significant changes that I've seen is in not so much to salaries, because there hasn't been a great increase, but post 22nd of July 2025 is the increase in the skill level for sponsorship. So gone is RQF levels 3 to 5, and to be sponsored it needs to be an RQF level 6 role, except unless there's certain exceptions that Kieran will cover shortly. But the general threshold increased, salary threshold, floor salary increased to 41,700. And the new entrant immigration salary list increased to 33,400. Kieran, if I can ask you to take everyone through the next few slides, please, I'd be grateful. Thanks.
Yes. Okay, right. So I will be going through the salaries under the codes with you, Tal. I will probably be asking you to move the slides forward if that's okay. So we had salaries pre-April 2024. So 4th of April 2024 is where they rose. Pre-April 2024, they were relatively, or they were certainly lower than where they are now. There was an increase come 4th of April 2024, so just a little over a year ago, 18 months ago, where they shot up considerably. I mean, we're talking 10 to 15,000 as the base and for the each occupation code. When you are looking at salaries, you have to meet both the relevant salary under the occupation code. So for each job, there is a particular occupation code. So if you've got somebody who will be employed as an electrical engineer, there is a specific code for that. So you have to take the salary under the code into consideration. And you also have to take into consideration the general salary set by UKVI. So both the salary under the code and the general salary. In addition, UKVI provide the hourly rate. So when you are looking at working out what the salary should be, note UKVI salaries are generally set at 37.5. So if you maybe do a 35-hour week or a 40-hour week, you can adjust it accordingly, but note you can never fall below the general salary. So whilst you can adjust the hourly rate based upon the code, the general salary stands, and that can't be varied regardless of the number of hours. Next slide, please. Okay, so options for salaries. There is obviously a significant impact of salary increases on existing skilled workers. I'm not going to spend a huge amount of time on pre-April 2024 sponsored workers, other than to make you aware of the difference, because I'm aware that the focus of this current presentation is on sponsoring people new from this point onwards. So anybody who was sponsored pre-April 2024, there are reduced salaries available for their continued sponsorship. They are located in options F to J of UKVI's table on how salaries can be worked out. So UKVI have accommodated the fact that there should be reduced salaries for those originally sponsored pre-April 2024. in order to select the exact salary that will be applicable, you do need to have an understanding of that individual's personal circumstances. Have they ever been sponsored pre-April 2024? Are they a new entrant, i.e. are they on the graduate visa? Have they just done a degree level qualification or above? As well as what the role is. So in order to work out the salary, you do need information on both the role and the applicant. Next slide, please. Okay, so these are your base salaries and concessions. Options A to E will apply to anybody who is looking for initial sponsorship after April 2024. Note option A, 41,700. This is your general salary. So when we refer to a general salary, this is what we're referring to. And then you also have to take into account the going rate for the occupation code. So if it's a particular, say, electrical engineering again, we know that the salary is 53,000, or if you're looking at certain types of, let's say, a business executive role, the salary is going to be much lower. So where the salary is lower than 41,700, you've got to pay them 41,700. Where the salary under the occupation code is higher than 41,700, you've got to pay them the higher salary. So it's whichever one is higher. There are still some concessions that are applicable. So if somebody has a PhD that's relevant to the job, you can reduce the salary under the code and also the general salary. So the general salary will be reduced to 37,500 and a 10% reduction on the code. C, where the applicant has a PhD in a STEM subject relevant to the job that they'll be doing, the base salary is reduced from 41,700 to 33,400 and a 20% reduction on the salary given under the occupation code. Then where you're being sponsored for a job on the immigration salary list, you can be paid a base salary of 33,400, but note, no reduction for the occupation code. So even if the role is on the immigration salary list has replaced the shortage occupation list, for those who are familiar with that. Whilst the base salary has been reduced, you still have to meet what's on the occupation code. There is no reduction for that. And the final one, option E, which I think is probably the one that's going to be most relevant for those who are on this presentation, is where the applicant is classed as a new entrant at the start of their career. Their salary is 33,400 as the general salary, and they can have a 30% reduction of what the going rate is. Again, the higher figure must be met. Next slide, please, Tal. Okay, now, again, I've put them up on screen, options F to J, but these are primarily for your pre-4th of April 2024 sponsorship and for those on health and care ASHE codes. So I'm not going to spend much time going through these other than making you aware that they exist. Option K may be relevant. Now, this is specifically for listed health and education roles. This will apply to those roles that are specifically listed for the purposes of option K. So UKVI decide which a role that it will be classed as a listed health or education role will be. And for those particular roles, the salary, the base minimum is 25,000, but you also must meet the going rate for the occupation code. The relevant codes for option K are listed in tables 3 and 3A, and the pay bands are different because if you looked in table 3 and 3A, you'll note that there are no salary figures given. You are given the salary figures, so NHS pay bands in table 4, that's for your health codes, and your education codes, they are you're given the going rate for those particular codes in table 5. These are your listed education codes. So next slide, please. So a skilled worker can only rely upon option A to E. So that will be primarily what we will be looking at, options A to E. They can occasionally rely upon the lower options, or sorry, to options beyond, so E, F and J, where they were originally sponsored pre-April 2024, and or they are being sponsored in a health and care occupation code. And the last one is C, where if you are being sponsored in a health or education role. Next slide, please, Tal. Okay, so I've left this in. I don't necessarily expect you to spend a huge amount of time looking at this slide. I've left this slide in to help people if they are looking to try and work out what salary should be paid. So there, when you are looking at the skilled occupations, you will see a range of tables: table 1, table 1A, 2, 2AA, and 2A3, 3A, 4, and 5. And some of the codes are going to appear over again. So there'll be certain codes in table 1 and 2, 1A and 2AA. The main difference is which table you should use according to when they were originally sponsored and what the role is and whether or not it comes in option K. So that information is here and available to you just in case you do want that to help you understand why the tables are set out as they are. Next slide, please. Okay, right. So let's actually have a look at some examples. So we've got fictitious business, Total Limited, and they have the following employees that they want to sponsor as skilled workers. Now we have Anna. She's a financial analyst. We've got her code. RQF level 6 is her role. Her current salary is 42,000 and her working hours are 35 per week. And her first COS in the UK was signed on the 3rd of September 2022. All of this information is relevant. We need to know where her post is skilled to, her working hours, and when her first COS was assigned. So Tal, next slide. Based upon that, we know that her initial skilled worker visa was pre-4th of April 2024. So we immediately know we can rely upon options F to J. RQF level 6, so we know table 2. Code 2422, salary under this code, specifically under table 2, is 34,200, £17.54 per hour. So we need to work out what the salary she will be paid will be based upon her hourly rate. That's 31,923. The general minimum, so the general floor salary for Anna, given that she is a pre-April 2024 original sponsored worker, is 31,300. Her actual salary is 42,200. So we're happy. We can extend Anna's visa easily. We're meeting the salary and we're happy with that. Next slide, please. And next we have Jyoti. She is a quality assurance technician. We've got her code 3115. Her role is skilled to level 3 to 5. Her current salary is 38,700 and her working hours are 37.5. Note her first COS in the UK was assigned 30th of August 2024. So after the 4th of April 2024 changes. Next slide, please. As we know that her initial COS was assigned post 4th of April 2024, we are looking at option A to E to decide what her salary will be. She was able to be sponsored in this role, which is skilled to RQF level 3 to 5. So we'll be looking at table 1A. The salary under the code is 33,400, £17.13 per hour. So we will work out what her salary should be based upon the code, and that is 33,404. The general minimum for Jyoti, however, is 41,700. Her actual salary is 38,700. So her actual salary is 38,700. But if you look at the two figures above, the general minimum 41,700, and then what we must pay her under the code, we know that we've got to increase that salary to at least 41,700 because both the figure under the code and the general minimum must be met. So if we extend Jyoti's visa, we can only do so by increasing her salary by £3,000. Next slide, please. Okay, so calculating salaries. UKVI no longer allow guaranteed bonuses and allowances. So they used to, but they no longer allow those. So the skilled worker salary figure is literally just the salary figure that they will be paid. The salary can be paid either in the UK or abroad. Salary deductions for loans, immigration costs should be subtracted, and then what you're left with must then meet the minimum. You can't pay a higher salary and say that's the salary when you are subtracting. So the salary you give must be after subtraction. The maximum hours that you can calculate a salary is based upon is 48 per week for salary calculations. So if somebody's working 50 hours, UKVI won't take the extra 2 hours into consideration. They will base it purely upon a 48-hour week. So just bear that in mind. Most businesses will go to a maximum of 45. I've occasionally seen 48, very rarely beyond that, but it's just worth being aware of that. UKVI will also take into account irregular work patterns. So you may have somebody who works 12-hour shifts, 3 days a week, 4 days a week. And then this can vary depending upon which week they're on. So they may have 1 week of working, say, a 75-hour week, and then the next week they've got the full week off. UKVI allow for irregular work patterns, but you have to take the relevant period into account. The maximum that this can be is 17 weeks. In my experience, it generally tends to be around 4 weeks, where you may have somebody working 2 full weeks on and then 2 full weeks off, or 3 weeks on and then 1 week off. And you can calculate and average out those working hours over that relevant cycle period. Worth bearing in mind, the occupation codes are based on a 37.5-hour working week, so the salary that you're given. UKVI also usefully provide the hourly rate, so you can always have a look at the hourly rate and easily work out what the salary under the code will be depending upon your particular hourly rate. Next slide, please, Tal. It's really important that you must pay the salary recorded on the COS. So often there'll be reasons given to me as to, well, we didn't pay them for this reason, or we didn't pay them for that reason. UKVI's expectation is that you will pay the salary recorded on the COS, and if there is a legitimate reason as to why this can be reduced, this must be reported on the SMS. So salary reductions should be reported on the SMS. Where salary reductions go beyond 28 days, then the idea is you need to be terminating employment. There are exceptions to that, the most common being maternity, sickness, potentially jury service. But the idea is unless there's an exceptional reason that the salary has been reduced or unpaid for more than 28 days, you should be terminating employment, or you make the report and you give the reason. For your information, UKVI will consider the reason that you give, and they may leave it at that, in which case that's fine, they've accepted it, or they may come back to you and say, actually, that's in the circumstances we think sponsorship needs to be terminated. So they will have a look at what reason you're giving. Temporary reduction in salary for health reasons must be supported by an occupational health assessment. It's worth bearing that in mind. So I'm not talking about just generally reducing for sickness, but where that is going to be ongoing for a significant period of time, you will need to look at potentially getting official information in the form of an occupational health assessment to suggest why that needs to be done and to back that up. And one of the key questions that we will frequently get is, for sponsored workers where salaries go up, do we now need to meet the new salary? So to be clear, when you sponsor someone and that's the salary that was relevant at that time, that individual can carry on that sponsorship period, on that particular salary for that full period that you're sponsoring them for. There is no requirement that you have to increase the salary where the salary is increased under the immigration rules. However, national minimum wage must always be met. So if you've got sponsored workers, regardless of their salary, they must always be meeting national minimum wage. So changes in skills thresholds. So pre-Brexit, the general idea was the visa was known as Tier 2 General, and the skill level was RQF level 6. And for years and years, it was considered that skilled worker visas, Tier 2 General, were for higher skilled roles, basically level 6 or above. With the advent of Brexit in December 2020, UKVI basically were concerned that we may not have that we may have shortages within certain areas of labour within the UK. So what they did was they basically reduced that skill level to RQF level 3 to 5, which was A level. So that skill level was reduced from December 2020 up until 22nd of July 2025. On the 22nd of July 2025, UKVI decided to increase that back to the original skill level of RQF level 6. What that meant is that we had approximately 180 eligible occupation codes that were made available between December 2020 and July 2025, which are now no longer available. Next slide, please. So this is, again, I'm not going to spend too much time on this. This is just to give you a quick idea as to what the RQF levels are. Again, to be clear, this is the skill level of the role, not qualification. So an individual doesn't have to hold a degree or hold a particular level qualification. The skill level of the role. So you may get someone who's got a lot of experience and has worked their way up in terms of being able to do a particular role, who might not necessarily have the qualifications, but has got a lot of experience, and you as an employer or employers can assess their ability to be able to do that role. So when we are talking about skill level, we are talking about for the role, not that the individual must hold that qualification. Next slide, please, Tal. Again, I'm not going to spend too much time on this, just to note that the sections that are highlighted in yellow are specifically for sponsorship for level 3 to 5. So all new sponsorship can only be in tables 1, 2, and 3, and 4. Next slide, please, Tal. Okay, so 22nd of July. So we've discussed a bit about what happened on the 4th of April 2024. On the 22nd of July, what UKVI did was they took away the RQF level codes that were skilled to 3 to 5, which meant that we lost 180 occupations. What they also did was take away the shortage occupation list and replace it with the immigration salary list, which is much shorter. And they also introduced this new list called the temporary shortage list, often known as the TSL. The current transitional arrangements in place following the changes on the 22nd of July allow for those who were originally sponsored in RQF level 3 to 5 codes to be able to continue being sponsored in those roles. All skilled workers, including those assigned a visa before 22nd of July, will be able to take supplementary employment in roles which are skilled at RQF level 3 or above. Next slide, please. Okay, so this is a bit of information about the ISL. The general salary is reduced from 41,700 to 33,400, but there is no reduction under the occupation code. So the occupation code must still be met. There are transitional arrangements for those who were originally sponsored pre-April 2024, as in they can be paid a lower salary. So to be clear, the applicant, where they're being sponsored for a job that's on the immigration salary list, ISL, their salary must equal either 33,400 or 25,000 if they were originally sponsored pre-April, and the relevant going rate for the occupation code. Note, no reduction in the occupation code. Next slide, please, Tal. So these are examples of ISL salaries. Again, I've given the post 4th of April general salary and salary under the code. Remember, you've got to pay the higher of the salaries than the pre ones as well. So let's just focus upon the post 4th of April 2024. These are roles that are on the ISL, so we can sponsor under them. Note that some of the salaries will still need to be increased quite a bit. So under the artist code, that's the first one that I can see where the general salary is 33,400, but the salary under the code is 38,200. So that's going to need to be increased to 38,200. Okay, Tal, next slide. So ISL calculation. So this is an example. We have Zola, who's currently in the UK. She's on a graduate visa and she's been offered sponsorship as an artist. Her weekly working hours will be 40. What should her minimum salary be? So code 3411 is on the ISL. She's post-April sponsorship. So the general salary will be 33,400. And the salary under the code is 38,237.5 per week. So we would need to work that out, and her salary based upon 19.59 40-hour week times by 52 would need to be £40,747.20. So this is higher than the general salary figure of 33,400. So what we're attempting to show with this example is, whilst your minimum has been reduced, because it's not reduced under the code, you're often still having to pay those higher salaries regardless of the fact that the minimum has actually been reduced. Next slide, please, Tal. So the temporary shortage list, again introduced 22nd of July 2025. The TSL is a list which is subject to ongoing change and subject to supply demand of roles in the resident labour market. So the TSL primarily covers RQF roles 3 to 5, which are linked to UK industrial strategy. They apply to COSs signed from the 22nd of July 2025 to the 31st of December 2026. All we're saying there is that the TSL was introduced on the 22nd of July 2025, and a number of the codes under this are due to be reviewed on the 31st of December 2026. It does not mean that you have to restrict sponsoring those individuals until only the 31st of December 2026. It just means that this code will be on the TSL until that date, and at that point it will be reviewed. Not necessarily removed, but it will be reviewed, so it may be removed. Post 2026 inclusion dependent on Migration Advisory Committee MAC, advice, workforce strategy and local recruitment efforts. It's time limited, no reduction in salary, and the temporary shortage list TSL can be found here. Tal, I think I'm now handing over to you. I don't know whether you want to give a bit more information on the on the Migration Advisory Committee. I'll just do this next slide and then I'll hand over to you. So we have an example of how to work out the TSL salary. Now, again, no reduction of salary. So this is one of the big changes. Whilst we've got this TSL, whilst we've got the ISL, there is no reduction for the salary under the code. For the TSL in particular, no reductions at all. So 3544 data analyst, this is a code that's on the TSL. For your post-April 2024 sponsorship, you are still going to have to meet the salary figure of 41,700, even though the salary under the code is 34,900, and UKVI accept that this is a temporary shortage occupation. They have not provided any benefit other than, okay, we accept it's a temporary shortage role, so you can still sponsor under it, but they're not giving us any concessions on salary. Another example is 3552 business sales executives. Again, this is an exceptional role that's on the TSL, exceptional in the sense that it's RQF level 3 to 5, but you're still able to sponsor it or for it because it's on the TSL. General salary here is 41,700, and the salary under the code is 36,700, which means that the minimum payable will be 41,700. Okay, right. So example TSL salary calculation. So we have Mei Ling, and she's currently in the UK as a graduate visa holder and has been offered sponsorship as a data analyst. Her weekly working hours will be 34. What should her minimum salary be? Okay, so we know she's post-April sponsorship, so we know that the general salary is 41,700, and the salary under the code is 34,900. 17.9 times 35 times 52 is what the salary therefore will need to be. And the salary under the code will therefore be 32,578. The above figure is lower than the general salary of 41,700, and therefore the salary payable will be 41,700. What we're showing here is that under the code, it's 32,578, but you have to uplift that for the general. What that means is that we've got quite a bit of extra hours that we can play with. So one of the things that you can do is increase the working hours. So in the first example, we've got 35 working hours. But in the second example, where we've increased that to 44, the salary still comes to 49.55, but note that that's still less than the general. So in this particular instance, the general 41,700 is the salary that's increased. It's increasing the amount we're having to pay in terms of a salary. So what we can do here, where we've got codes where the salary isn't that high, is we can actually increase the number of working hours. And what we can see is that we're going to be having to pay mailing 41,700, whether she's working 35 hours or whether she's working 44 hours. So it's a way of making that salary more effective. I'm also aware that I have not, that there may be the graduate visa holder discount of being a new entrant, and that hasn't been taken into account in this slide. We're doing it purely for the purposes of just trying to show a TSL calculation. Okay, next slide. Right, so this is relevant to dependents. Again, 22nd of July 2025 changes. So anybody who's sponsored under an RQF level 3 to 5 role post 22nd of July 2025 can't have dependents on their skilled worker visa. That will basically mean all roles on the TSL, because they're all RQF level 3 to 5, and certain roles on the TSL if they are considered to be skilled to RQF level 3 to 5. Anyone sponsored pre-22nd of July, they can have dependents, because this rule only came in on the 22nd of July 2025 and only applies for sponsorship post that date. Next slide, the future of ISL and TSL. Okay. Both ISL and TSL are due to be reviewed in December 2026. That's all we've been told at this moment in time, that they will be reviewed, not that they will come to an end. It's possible that they will codes on those lists will continue. It's possible that other codes may be added. Again, I'm highlighting that you can sponsor on the ISL and TSL for up to 5 years. This date of December 2026 does not mean that you have to limit sponsorship until that date. Some codes are on both lists. Why? The UKVI haven't provided us with the reason as to why. The only thing I can say is, each time that you're looking at trying to assess what the salary should be, it's worthwhile looking at all possible concessions that apply. And as we know with the ISL, they have dropped the general salary. So if a code appears on both, you have the benefit of the general salary being dropped. That may or may not have an impact depending upon what the salary under the code is. Okay, Tal, I'll hand back over to you.
Thank you for that, Kieran. Okay, so I'm going to have to go quite fast through my remaining slides. I think one of the main things discussions that we have with employers is we're not going to employ a graduate visa holder or international student, not so much because of the new entrant salary that might be applicable, but what we're seeing with a lot of our clients is that they're forward planning and seeing that once the new entrant concession comes to an end, a maximum of 4 years, then what's the going rate salary going to be? And quite often that's something that does put employers off. So, we acted for an architect's practice who was saying that, with the example that I'm giving here, that they were unable to pay 47,600 as the going rate salary once the new entrant discount was over, because that's a salary they don't pay to their resident workers. It would be too high, and in that situation. And what we did there was we looked at other occupation codes, which might also be a good fit for the job role and job description of the individual that they wanted to sponsor, both at the time of them being a new entrant and then long term. And in that particular case, we did come up with an alternative code of 2452. Where you'll see that the going rate salary was actually significantly lower than the related salary above. So the message there is, do look at occupation codes in the round and see which one is the best fit, and particularly where salaries are an issue, is there another code that might be better? You also need to look at the cost of a skilled worker application, and I've got this here in two tables. And the reason why I've put this here is because the UKVI in December 2024 and then again in April gave guidance as to clawback clauses and what a individual's responsible for and what the employer's responsible for. So on this side is all the costs that you cannot pass to the individual. And these are the costs that must be met by the individual. But we're aware, many businesses will either will pay this for the individuals and either have a clawback clause in the contract of employment or maybe have some sort of a loan arrangement. And as Kieran touched on in one of her previous slides, what the UKVI have said is that if you're going to have a clawback clause or a loan arrangement, it must not reduce the overall salary below the going rate salary for the particular occupation code which the individual is on after deducting the clawback. The other thing is that if there is a premature end of employment, meaning that the amount payable either in a loan or clawback becomes applicable, you must report that on the sponsor license as a reduction in salary, and the reason will be premature end of employment. And in that situation, the UKVI have confirmed that they will not take any action because the person isn't going to continue to be employed by the organisation. But what they are keen to look at, particularly during sponsorship audits, is clawback arrangements. Is it fair? Is it unreasonable? Is there sort of debt bondage going on here? And therefore do take advice from employment lawyers, from your lawyers, as to your clauses and also review clawback clauses in your current arrangements, just to see that they are meeting the current requirements. The immigration skills charge, it was confirmed last week that this is going to be increased by 32%. This is now going through the parliamentary process and will come into effect in the coming weeks, which means that for a large employer, the immigration skills charge is going to increase to £1,320, and for a small employer or charity, £480. Action for employers, if you have the time and if it's applicable to certain of your colleagues who are being sponsored, is to assign certificate of sponsorships now, if possible, to reduce the cost. And again, I will emphasize that there's no immigration skills charge for switching students directly to the skilled worker route. I want to also quickly talk about the government authorised exchange scheme, and I'll ask Andy to put a link to Appendix N in the Q&A, which has a list of all the schemes that the government approved. Now, the benefit of this scheme is that it allows you to take someone on in your organisation to gain as part of an internship or work experience or to work in your organisation. The only point you have to note is that the role must be supernumerary to your existing requirements, meaning that they're not the person that you're going to hire through a government authorized exchange visa isn't going to be taking on a vacant position, but is supernumerary to that role. And if your if a scheme allows for roles in science or medicine, fellowship and training in these fields of research in science and medicine, then you can have someone working for you for up to 24 months, and in all other schemes for up to 12 months. The salary will be governed by each scheme, and generally, so long as you're paying the same rate as you would do for a resident worker, that's all really the scheme holders will be looking at. The individual can only carry out the job for which they're being sponsored, and they can bring their dependents, and the government authorized scheme is not extendable, meaning that the person can then, after this scheme, switch into the skilled worker route or any other visa that's applicable to them. So I'll give you an example here of how this worked with a particular client that we represented. Fictitious scenario here, though, given. So Tamara is a US national. She's a graduate of Stanford University School of Engineering. She has been offered a 12-month internship with a civil engineering company in Scotland before she commences a master's degree at the University of Birmingham. The company is, however, unable to sponsor her despite having a sponsor license, as the minimum salary that they would need to pay her would be higher than that which they pay interns, resident interns for this role. So in Tamara's case, the appropriate scheme that we looked at was one called Twin Training International. And this scheme offers overseas engineering students, both undergraduate and graduates, work experience with engineering companies in the UK. Because it's a non-science, non-medical scheme, work experience, the maximum duration was for 12 months. So she was able to do that. She then went off to university to do her course, and she has then subsequently been sponsored by the organisation in Scotland. You could also use this scheme if someone's graduated in the UK as an alternative to skilled worker sponsorship or the graduate route. So discrimination. Nothing has really changed in terms of the rules since last year. And the key points to note here is that a business can't refuse to sponsor a migrant because they require sponsorship. And the UKVI's own guidance on best practice is to refuse applicants based on merit, and that right to work check should happen later in the recruitment process. There will always be exceptions, and this isn't a complete list, but just some examples that I've given here. So we are aware that there's certain businesses, particularly in military defense, that for national security reasons are unable to sponsor or hire nationals from overseas nationals. It may well be that you have a time critical delivery of a contract that you have to deliver to your customer or client, meaning that you don't have the time to be able to, if you don't have a sponsor license, to acquire one. But if you do have a sponsor license, to be able to go through the process of being able to sponsor the individual and get them in place in order to deliver that contract. You should, though, be very careful of using that as a reason, because whatever else you may say about the UK Home Office, it is one of the quickest to be able to land someone in the UK and start working on a skilled worker visa compared to other jurisdictions. You know, if everything aligns, potentially you could get someone over and sponsored with you within 2 to 3 weeks. This is an obvious one. The skill level for the job is below that for which a skilled worker visa will be issued, or the salary on offer is below that for which a skilled worker visa will be issued. I guess, you know, if you were sponsoring someone as part of a graduate apprenticeship role, based on my previous slide, you could also use that as a reason as to why you're unable to sponsor someone, because they don't meet the residency requirements for apprenticeship. So you have to look at each reason and see whether that's going to be justified, and indeed whether it's going to be fair and reasonable, and whether it will stand in a tribunal court, in a employment tribunal case. The leading case still is Osborne and Clark, which I'm sure you're all aware of. And what this quote here is basically saying is that the more resources that a business has, and you know, in terms of people, turnover, etc., the less it's going to be able to use a reason not to sponsor someone. Conversely, if you're a startup business, if you're a small business, you could potentially argue, based on this quote here, that you don't have the resources or the funding to sponsor someone. But, you know, again, that is something that would need to be tested in an employment tribunal. The key is to ensure that you're able to justify your reason for not taking a job applicant further, based, you know, if it is a migrant that requires sponsorship, and you know, that's certainly when we're doing presentations to our university clients, we are saying to students that if they feel that there's been something untoward in the recruitment process, to ask for written feedback, and we currently are in the early stages of a job application that seemed to be refused by HMRC of all people, based on the fact that after they offered the role to the person, they're now saying that the manager that interviewed did not realize that the individual would require a sponsorship, and it's a role that they don't offer sponsorship for. This is all in writing, and now we're opening them up, so it'll be interesting to see where that goes. I'm just going to leave these as examples of actual job adverts that are advertising that I've seen from well-known organizations, household names in their particular sectors that really should have known better than to construct advertising like this. This will set you up for a discrimination claim. But both in how you tailor your job adverts and the recruitment process thereafter, do ensure that you don't fall foul of discrimination. Certainly at Paragon Law, we will do blind applications to ensure that people have been selected for interviews on merit, and then it's only at that stage, when people come to interviews, that we will request that they bring evidence of their right to work. Okay, so what's still to come? English language is going to increase to level B2 for skilled workers. Those who are going to come as high potential individuals, and scale up visas from 8th of the 1st, 2026. It's not going to apply to extension applications, who will continue to be able to use B1 if their initial application was to use for a visa was under B1. There is, at some point, it wasn't announced in the immigration rule announcements yet last week, but there will be a stepped English language requirement also for dependents that will be introduced. So a lower level for initial entry clearance, a higher level for at the extension stage, and then even a higher level at the indefinite leave to remain stage. The points for you to note is that skilled workers may wish to sponsor dependents now to avoid future language test requirements. In certain sectors, these changes may deter international applicants, and you may want to consider workforce planning. TSL, as Kieran said, job holders won't be able to sponsor dependents, which also further limits talent appeal to come to the UK. So there's a lot of talk about settlement for, being increased from 5 to 10 years. It's going to be some sort of earned pathway to indefinite leave to remain. It's going to be a points-based system, which I think they're also going to introduce both for settlement and then again at citizenship, depending on what sort of contributions have been made to the economy and society. No firm details, and the Home Secretary has said that there will be a period of consultation, which should come in this next sort of quarter. There is legal precedent of a previous case which concerned highly skilled migrants. There was a visa called the Highly Skilled Migrant Program, where they tried to do the same thing, change the settlement requirements retrospectively. And in that case, it was held by the High Court to be unlawful. And therefore, whether they're going to be able to do this, whether the UKVI will implement this retrospectively, is one to be really seen. But will we be able to challenge that in the courts? I'm not sure, because this was very much based on its own facts. Whereas, if the UKVI, if the government wanted to change the law, there's nothing actually preventing them to introduce this retrospectively as well. And so for your planning implications, what you really need to be looking at is the additional cost of supporting workers for 10 years instead of 5 years. You saw my previous slide of the immigration skills charge, the certificate of sponsorship, etc. So you may need to plan that in as part of your costs. The UK's potential move to a 10-year citizenship would be the longest in the developed world and will impact us in terms of international competitiveness. And I've given Canada there as an example. And if there is a consultation, it is very important that you respond to any such consultation as to how this is going to impact you in your sector and how you compete. But also look to see how quickly you can get people on the path to settlement. So again, those that you are looking to sponsor, perhaps sponsor them sooner, so they're in that process.
Tal, can I? Sorry,
Yeah.
to interrupt. Just wanted to jump in quickly, if I may, just because I'm aware of quite a number of questions that have come up, particularly around looking at it from the practicalities, and that's what I guess I would echo from my experience, and it's been so much detail given. But I guess from an employer's perspective and from a university's perspective as well, but I'm going to voice it from an employer's perspective. You have a small team, right? You have thousands of applications, and we know currently with AI that is making ever more. Our recent survey said 140 applications per place, and we've got most of our members with tiny teams. Most applications are also reviewed manually in some way or other. So that's a huge number of applications. And I think a lot of the concerns that we're getting from members echoed on the Q&A is we have to be bound by discrimination law, but there have to be reasons where sometimes we just can't progress an applicant, and therefore we would want to not put ourselves in the position of starting to pursue an application. The examples that I think people would say, well, a couple, if your substantive salary for the role is never going to meet the threshold for skilled worker visa, is that a justification to say, well, we just can't accept applications from international students because we are never going to pay you enough to get the skilled worker visa?
Let me just answer that one first. I
Yes,
actually
sure.
think that's actually potentially a good argument, because the argument there is, look, you're going to train and invest in this individual for the initial 2-year visa. Let's say you're going to sponsor someone for the initial training program of 2 years. And then using that architect's code that I used as an example, they then have to jump to a salary of 46,000. If you can justify that with also saying, look, we're not going to pay our home residents this, I think that's an arguable case. What I've seen time and time again is, and I'd love to test this one in the tribunal court, is where employers are saying is, we're not sure if you're going to stay after 2 years. We don't want to go through the cost of sponsoring you now in case you leave, but you can't say that. You don't know whether a resident worker is going to do the same.
You can't read anyone's mind, can you? But I think that's again what members are saying. So if and Kieran was incredibly helpful with explaining about it's always the higher threshold within the pay, and so people are saying, well, but a lot of our members as well will be hiring a graduate cohort, so it's not ones and twos, it's a cohort of 80 or 100 or whatever, and there'll be a salary. Certainly where I've worked before, the graduate salary is the same across every graduate pathway. So if you would have to pay an international student more than your graduate salary in order ultimately to meet the thresholds, would that also then be what reason? Well, we can't discriminate positively in favor of international students by paying them a higher salary just because we would have to in order to meet the threshold.
Absolutely, that's a good reason to not take an application forward. And in fact, I think when the salaries were increased in 2024, April 2024, throughout the SOC codes, you had the likes of KPMG, I believe Rolls-Royce and others who said that we're not going to be able to take graduate trainees any longer because of the salary that we have to pay them is going to be higher than our resident workers. And we can't, because of wage inflation, we're not going to be able to increase everyone's salary.
Thank you. And a couple of other things just related to that.
Sure.
So then when and again, from my experience, people take on undergraduates for internship placements, undergraduate placements, or whatever the terminology, typically for their graduate pipeline, because they would do that year, or they'd do whatever period it was, go back to university, ultimately come and join you on your grad program. And often those would just be mapped to roles. So they'll have gone through the selection process for undergraduates And if they do a successful placement, you'd want to transition them to the graduate. Now, if the same premise is, as I just set out earlier, that your graduate salary will never be sufficient to meet the thresholds, is that a justification for saying, therefore, for our placement program, we will not consider student visa applicants because they could never be converted?
So this is whilst they're undergraduates, they won't take someone on an internship or that 1 year part of that sandwich course or whatever, because what's going to happen in the future?
Yeah, because
I think
if their
so.
argument was it wouldn't, if their argument, sorry, to make it perhaps a little bit clear, is that we are only looking to take on these undergraduates because they would become graduates. Not all of them will, but that will be partly their choice and also potentially performance. But if our premise for our undergraduate scheme is that it is specifically a pipeline for the graduate scheme, could an employer take the view that because of the salary threshold would never be met, there is little point in them taking on
I
a
think that's, yeah, I
student?
think, Anne-Marie, I think that's arguable, so long as they can demonstrate that it is the pipeline used as such.
Okay,
They can demonstrate, historic data that undergraduates do then move on to the
that is
graduate
what.
program.
Thank
Yeah.
you. And sorry
Everything
to
is evidence-based there.
Okay, and just one final thing on my interruptions, and I really apologize, but I wanted to make sure I got these questions out. If the reduction in the graduate visa, the post-study work visa, goes to 18 months, and and your graduate program is, say, 2 years or longer, but longer than 18 months is the key one, and if that graduate is an international student and they're coming in on a graduate visa, but the graduate salary throughout the graduate program, because it's a 2-year program, it's a 3-year program, will never meet the threshold. What then happens? Because the graduate visa would now expire, the threshold would be lower. So would it be that as the graduate visa expires, you would have to put them on a skilled worker visa, and therefore potentially you'd have to just pay them more than other people, which goes back to my earlier question?
Yeah, absolutely. That's what would need to be done, and there could be a argument there potentially. Is it unreasonable to stop the graduate program at 18 months and say we're not going to sponsor you any further? I
Yes.
think that's where the graduate visa holder may have an argument.
Thank you. I just wanted to get those in. So sorry, Tal, I will let you complete what you wanted to say.
That's absolutely fine. And in fact, we can do questions now, or I can quickly, I've got about 2 or 3 more slides. I know we're over time here. Shall I continue, Anne-Marie, or do you want to go?
Yes, I mean we posted it till 2 o'clock, so we've got a bit more time. Yeah, so
okay, fabulous.
we've got
Okay.
a bit more time for the slides, and also
Okay.
and I'll pick up some final questions at the end. So if you just leave me at least 5 minutes.
Will do. Okay. So look, one thing that was in the immigration white paper in May, and if you look at page 25 of that document, is that they want to review the new entrant discount. It hasn't come up in the July 22 changes or October 14 changes, but they do seem to be going through everything systematically and saying that they're going to do everything that's written on the tin. So we can assume that at some point they're going to look at this, and their rationale in the white paper for removing the new entrant discount is to ensure that international hires aren't seen as cheap labor. So there are key issues here that, firstly, there's the regional pay gaps, which make sponsorship quite often unviable outside of London and the Southeast. And regional employers are already, in discussions that we're having, finding it difficult to compete for talent and persuading talent to come to the North. There's also going to be graduate program disruptions, already an increasing disparity between graduate salaries offered to resident graduates and higher salaries, something that we were talking about now. And also the disruption to training pathways. So certain professions such as mine, which is law, and then other professions, pharmacy, opticians, rely on the new entrant discounts to hire trainees, which may no longer become viable. But then the UKVI may then introduce a scheme under the government authorised visa that I was talking about in a previous slide, whereby they may allow the General Optical Council to have a Tier 5 scheme that allows them to sponsor opticians on behalf of training opticians on behalf of Specsavers or Vision Express to go through the training. So they may look at things to offset this, but it's again, we're just going to have to wait to see what happens in that regard. There are going to be fewer sponsorships for international graduates based on what's going on here, and potentially the UK loses appeal for early career global talent. They're also looking to reclassify SOC codes and graduate jobs potentially because of this reclassification may lose out on sponsorship. So you've already seen certain roles in sales, HR, and marketing that are no longer skilled at RQF level 6, but unfortunately they're currently in the TSL list. But if, again, these are reviewed by 2026 and some of these roles go, it is going to impact quite a number of international students, that are studying courses related to these types of fields. So again, there'll be fewer roles which will qualify for sponsorship, potentially difficulty attracting diverse talent. Challenges for universities in placing international graduates in the UK job market, and therefore really the call to action here, both for employers and universities, is to use case studies to show the long-term value of graduate hires and promote how it promotes progression from new entrant roles to leadership roles amongst international community, the brightest and the best. This does seem to be some sort of a disparity between what government says in the public versus what they also are saying behind closed doors to industry and businesses as well. They do realize that this is potentially a good opportunity for the UK to be competitive in a global market, particularly as the US with its HB1 visas is restricting things for international hires there, that they want to also ensure that the brightest and the best either stay or come to the UK. So I think it's going to be a really good opportunity for universities and for employers when the MAC in the next 2-3 months open their consultation on all of the white paper issues that we've discussed, that you really look at how you're going to respond to the consultation and what kind of things you're going to demonstrate to show why international hires remain important. So I've just put some of my thoughts on what you will need to do as your plan of attack, but you have to respond both as a sector, as part of your sector, as individual companies, and also as regional powerhouses as well. Your representations are going to be important in so many different places, and don't shy away from the opportunity, because in short, the government is just really, it was never in their manifesto before they came into power that they were going to do all this, but it's knee-jerk reactions again that are happening, which we could potentially persuade them not to do otherwise if the data shows the benefits of international hires, and how they're benefiting in your organizations and to your organizations as well. Okay.
Thanks, Dan. I think very illustrative of the fact that there's been a lot of things announced in government, the skills agenda, industrial skills strategy, and so forth, and it does seem a very changing landscape, which I think employers are quite naturally are struggling to navigate. Thank you so much for all of the information. I appreciate there's been so much information out there for members that they're probably a bit sort of needing to go and have a quiet cup of tea after this to sort of absorb it all. I think that one thing I was going to add, you put up some very useful do not do this with the application form question. As someone who has many times had to construct an application form question, and mindful of the things that I've said, that there are legitimate reasons why small teams of recruiters, they are never going to be able to take on an international student for the reasons that we have described. How is there any guidance as to how they stop them therefore applying? Because is there anywhere they can go for a set of words of how to say we cannot accept applications because?
That's very subjective to each organization, in terms of why they can't accept it, why they can't base applications on merit. I can't say that there's one blanket overall reasons that or a set of reasons that you can use.
Okay.
But it is certainly work that I've done with a number of organizations who've been tailoring online applications, some better than others. In
All
terms
right,
of
thank you. And so just to wrap up, because we're 1 minute left, huge amount of information there. Just to reassure members and attendees to this call, the recording will be available, and you'll be able to watch again and therefore remind yourself of everything. What I'm going to do as well is I will be doing a summary blog broadly of this discussion, so that will be coming out to our members as well. I will try to encapsulate as much of that in short form as I can, and I will also look to potentially another roundtable. I think it would be really interesting for some members to perhaps get around a roundtable to talk about how they are addressing and managing, given all of the changes and given the guidance that you've so helpfully set out for people. But thank you so much to Tal, to Kieran, to Adam for getting on those questions so quickly, because we'd have never have ever been able to cover them right at the end. Really appreciate the amount of time and effort and detail that you've gone into. Thank you very much for being such positive supporters of the ISE, and I hope that all our members have found that incredibly helpful, incredibly interesting, left them with more questions, but I will make sure that we follow up as an organisation with our members on those. So thank you very much, and hope everybody has a good afternoon.
Thank you, Anne-Marie.
Thank you.